Happy to see you all here. So I'd like to start this off by asking you to consider a hypothetical situation. Most of you are students here at UVU, a state school. So let's imagine that you go home after class one day and you write an inflammatory political post on Facebook. And your post goes viral, and it comes to the attention of the administration. And the administration decides, we don't need no rabble-rousers here at UVU. You're expelled. So you've been expelled for your Facebook post. What would you do? What kind of recourse would you seek? Ideas? Let's assume you're not willing to just sit and take it. You want to fight for your rights. You'd sue the university. You would go to court, right? And you would say, listen, court, UVU is a public institution, so it counts as a government actor. It's subject to the Constitution. The Constitution has a Bill of Rights. My First Amendment rights to free speech have been infringed, so you need to take action against the university and tell them to reinstate me. So that's exactly the answer I was looking for. And my point is that this is a very American response. That doesn't mean it's a bad response or a good response, but I think in the United States, people broadly accept this idea that the courts and judges have this final authority to interpret the Constitution, and if they decide that the government has infringed the Constitution, they can order a remedy. So in this case, they would tell the government school to readmit you. In other cases, judges might strike down a law on the basis that it infringes the Constitution. So for example, you may all know that 50 years ago in Roe versus Wade, the Supreme Court interpreted the Constitution as including a right to an abortion, so it struck down a variety of laws that were prohibiting abortion. Likewise, the Supreme Court might strike down gun control laws on the basis that they infringe the Second Amendment. And this model of judicial review has been influential, has definitely had an impact in constitutional reforms in other countries. For instance, it's commonly said that Germany has the most powerful judiciary in Europe, so the German Constitutional Court likewise has the power to strike down laws that infringe the German Constitution. But what I'd like to bring to your attention today is that this situation's far from universal. So even if we're restricting ourselves to, respectable liberal democratic countries, throughout most of their history, most countries have not given the courts this power. For instance, the UK, the United Kingdom, has long operated under a system of parliamentary supremacy. So Parliament, the legislative branch, which is kind of like the Congress here in the United States, is supreme over all political institutions, including the courts. So in the UK, traditionally, the judges had no business striking down laws, even if they thought the laws were unfair or problematic for whatever reason. Now, you might say, well, that sounds pretty crazy, right? It's possible for legislative bodies to pass all sorts of unfair laws. Maybe it would be a good idea to have judges monitor lawmaking to some degree. And that's why over the past 30 years, some countries have kind of gone to a middle ground. These are mostly countries that used to be British colonies, like Canada, my home country, Australia, New Zealand, and even the UK itself. So they were starting off from a position of parliamentary sovereignty. And they're saying, we want to involve the judges a little bit, but we don't want to go all the way to the American model and give the judges too much power. So you might ask yourself, how does this work in practice? So let me quickly explain to you how it works in a few of these countries. So Canada in 1982 enacted a Bill of Rights in the Constitution called the Canadian Charter of Rights and Freedoms, kind of similar to the US Bill of Rights in some ways. And the Canadian courts do have the power to strike down laws if they think that the laws violate the Charter of Rights. So in this respect, it's similar to the US. But the difference is that the Canadian Constitution includes something called the Notwithstanding Clause. And this is a clause that the government, whether the federal government or a provincial government, can invoke this clause to prevent the courts from striking down laws on the basis of inconsistency with the charter. So if a court says this law needs to be struck down because it infringes a constitutional right, the government can come back and enact a notwithstanding clause and say this law will operate notwithstanding the judge's opinion. Now, the courts have even less power in New Zealand and Australia and the UK, and the UK kind of changed in this respect. In 1998, it passed the Human Rights Act, which kind of gave the courts more power than they had before, but still not as much power as the courts here. So in these countries, there is a Bill of Rights, but the courts, if the courts determine that a law infringes a right, they do not have any power to strike down the law. So what can the courts do? They can do one of two things. The first thing is that they can interpret the law in a way that does not infringe the right. So the court could say, look, if we interpret this law to say X, it's going to infringe rights. But if we interpret law to mean Y, it will not infringe rights. So we're going to interpret and enforce the law as meaning Y. However, nothing prevents the parliament from coming back and saying, no, actually, we meant X, and we don't think X infringes rights. So we're going to pass this law again and clarify in the law that this law means X. And in that case, the court really can't interpret it in a different way anymore. Another thing that courts can do in these systems is that they can issue declarations of inconsistency. So the court doesn't have the power to strike down the law, but the court just says, we declare that this law is inconsistent with this constitutional right. Now, the parliament is not necessarily under any obligation to do anything. It just sees that a court is saying that the law is contrary to a right. But the hope and the expectation is that, these are not tyrannical countries, that the legislature, the politicians, should seriously take the judicial opinion into account and consider changing the law if they think the court's right. But sometimes they may think that the court got it wrong. So the theoretical justification for this system is that we want to share the responsibility for protecting rights and crafting public policy between courts and legislatures. The idea is we're not going to trust the courts to get it right 100% of the time, and we don't think the legislature is going to get it right 100% of the time, so we're giving both of them a role. But if they do disagree, the last word does go to the legislature, to the politicians, on the basis that they're democratically accountable. So if someone has to make the final decision, it might as well be the people who get voted into office and who can get kicked out of office. So with this, I will turn it over to Dr. Brogdon.
All right, so the middle way. We don't let judges just decide what the Constitution means, but we also don't just have politicians running unrestrained and roughshod over our rights. I guess the question I'd ask is this that much different than the way it actually works in the United States? So we often think of courts getting the last word, but we actually have some ways to limit its effect, sort of push back against them. So can think of some cases where courts didn't really win that struggle, or at least didn't win it very quickly. Famously, Lincoln faces down the court in the Civil War, sort of refuses to acknowledge the legitimacy of the Dred Scott decision whenever he becomes president. And Republicans in office at the beginning of the Civil War just sort of ignore what the court had said about some of these issues in the Constitution. Is that any different than the sort of middle way? I mean, is this just like Canada and New Zealand and so forth, kind of institutionalizing what we would call departmentalism in the United States, where the president or Congress can really push back, sort of refuse to let these judicial decisions go into effect?
Yeah, I think it's fair to say that the difference is that it's being formally institutionalized in these countries. It's being formally written into the Constitution. So the way that these disagreements would be mediated is actually more or less clear based on the text of the constitutional document. Whereas in the United States, I don't think the text is clear as to where interpretive authority lies, right? So you'll have the courts in cases like Cooper v. Aaron claiming to have, final authority, but then you'll have presidents like Lincoln saying, well, that's not right. As president, I'm not bound by what the courts think. I would say it seems to me that that ever since Brown versus Board, maybe, I think American culture kind of leans in the direction of judicial supremacy. At least in popular culture, people kind of expect Congress and the president to obey the courts. People, nowadays, I mean, Trump may or may not be disobeying some district courts, and you have lots of people talking about a constitutional crisis. So I think this idea of departmentalism is definitely controversial. Maybe you could speak some more recent examples where you may think that maybe it's more common than people assume.
No, that's a good question. I'm actually curious, before I say anything else about this, like we've described some alternatives to the way Americans do this that sort of reduce the power of judges a bit. So I'm just curious, like your knee-jerk reaction for the audience. How many folks think like courts are too powerful in America and we'd be better off with one of these other systems where we found some way to sort of moderate or reduce the power of courts in constitutional questions? Anybody? No takers? Okay, all right. John, that's right, John's here. So Americans have a really high level of confidence in this generally, or at least the sample of students and faculty I've got sitting in front of me up here certainly do. First of all, I think it's helpful to define some of the things that we mean whenever I say that other people push back against courts. Courts aren't really final in the United States on a lot of questions. Here's one distinction that's probably helpful. And I'm actually stealing this from Abraham Lincoln, right? So you guys probably know that the Supreme Court in Dred Scott versus Sandford in 1857 says a couple of really controversial things. They say Congress cannot forbid slavery anywhere in the United States, even in federal territories that aren't states yet, right? So in other words, they can't stop the extension of slavery to new territories. So that's one of the things the court said. And then another thing the court says is people who came here from Africa, people of African descent, can never be citizens of the United States. Now, these are both things that the Constitution doesn't expressly say anything about. Constitution doesn't say anything about, didn't say anything about who can or is a citizen before the 14th Amendment did that. And the Constitution doesn't expressly say one thing either way about what Congress can do with respect to slavery. So we've got this big disagreement over these really important issues which are bubbling up into civil war, right? This is as big as a political issue can get, and the court says, we're going to settle these undecided constitutional questions for you all. And Lincoln says, if that's true, the people have ceased to be their own governors. If 9 lawyers in black robes decide what our Constitution means, we don't have self-government anymore. That's sort of Lincoln's response. Now, that's a very catchy sort of campaign stump kind of thing to say, So what do you mean specifically? Did he mean like the president can just ignore whatever the Supreme Court says? And Lincoln says, no, that's not quite what I mean. Lincoln makes a distinction. He says, when courts decide a case, there's a difference between them deciding the case, that is the controversy between the parties. So in Dred Scott versus Sandford, there was a legal controversy between Dred Scott, a man who was alleged to be a slave, and his owner, or alleged owner, John Sandford. There's a legal dispute between those two people. And Lincoln said when a court decides that dispute, who wins between John Sandford and Dred Scott, nobody's got the right, not the president, not Congress, to overturn that decision. That's a decision of a court of law in a specific case between parties. And that's final. The decision of the case is final. He said, but that's different than the decision of the question. He said, the court not only decided the dispute between John Sandford and Dred Scott, after all, the court could have just said, John Sandford wins. One sentence opinion, right? They didn't actually even have to say why. They could have just not even said why. They could just say, John Sandford wins, end of case. Lincoln says that'd be final. But they didn't stop there. They gave reasons for why John Sandford should win that case. And what Lincoln says is that the reasons the court gives are not final. So they decided one person won, okay, nobody can change that. But the reasons they give for it, the question of law in the case, does the Constitution allow Congress to regulate slavery in the territories? He says that is not settled by the Supreme Court. In fact, he says no institution can fully and finally settle that question. He says actually there's one way to completely and finally settle that question. You may know what that would be? How could you completely and finally settle a dispute over what the Constitution means? An amendment. We got an amendment process. Article 5 of the Constitution says we can change it, and Lincoln says that means we the people can make a change in our Constitution, and that would finally settle it. By the way, we the people have actually done that in response to Supreme Court decisions several times. Anybody give me examples? What are some examples of us overturning Supreme Court decisions about the meaning of the Constitution using the constitutional amendment process? Anybody know any examples of this? Uh-huh. Well, we did overturn a constitutional decision, but the people overturned their own constitutional decision. So first we prohibited alcohol, and then we decided a few years later, not a great idea. We sort of overturned ourselves and repealed it. That's right. Yes, ma'am? Okay. Yeah, the court did. That's right. So the court came back almost 50 years later and went, I think we got that one wrong. It's not the first time they've done that. They actually did that with racial segregation. They had decided it was okay in the 1890s, and then in the 1950s they said not so much. The court's overturned itself a number of times, but sometimes the court sort of refuses to address that. And after all, I don't really want to wait 50 years for the correction of an error. Like, do I really have to live with the Supreme Court's mistakes for 50 years, half a century? Seems like a long time. So actually, we've done it a little faster a few times. We did this very early on, like the first, after the Bill of Rights, the very first constitutional amendment, the 11th Amendment, overturned a Supreme Court decision about the extent of federal jurisdiction. It's a boring provision. You probably haven't read it. But if you do know, the Supreme Court decided a case that said something about the power of federal courts, and the people said, no, we don't think so. You're wrong. And we just expressly overturned it.
Is it Chisholm versus Georgia?
Yeah, it was the Chisholm decision. Chisholm versus Georgia, and I won't get into it. But, yeah. It was overturned. In what way? What part of the decision gets overturned? Constitutional amendment. That's right. You all know now, because we've been having a dispute over birthright citizenship, that we put a definition of natural-born citizen in the Constitution. Put it in the 14th Amendment, which is passed in the wake of the Civil War, and says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. We have some disputes going on about just who all gets included in that, but a group that it definitely included were people born into slavery on American soil. Those people became U.S. citizens the moment the 14th Amendment was ratified. So those are a couple of examples. There are a few more. The income tax. Congress tried to impose an income tax. The court said it was unconstitutional. We passed an amendment. Said, no, we don't think so. Actually, we can have an income tax. So we've done this a few times. So that's at least one way you can do it. But what Lincoln was talking about was actually a situation where the president or Congress disagree with what the court has said about the Constitution. So the court said Dred Scott's still a slave because Congress can't regulate slavery in the territories. Republicans turned around when they got in office a couple of years later and passed a new law forbidding slavery in federal territories, doing exactly what the Supreme Court said constitutionally they may not do. Now, that had no bearing on Dred Scott because they didn't name Dred Scott in the thing, but Congress was doing something and the president was signing a law that the court had said previously was unconstitutional. Lincoln says it's fine. Perfectly fine. In other words, the political branches can keep trying, right? I used an example recently. I was chatting with somebody about this. I said it's sort of like, we think the Supreme Court's an umpire, like in Major League Baseball. He's behind the plate calling balls and strikes. The Supreme Court justices even say this. That's not what the Supreme Court is. The Supreme Court's one of the players, okay? This is not Major League Baseball. This is pickup baseball in your neighborhood. There's no umpire. The umpire's playing the game. Some kid playing first base is like, that was a ball, you know, and I don't know, are they going to win? They going to get their way? Or pick up basketball, somebody's like, that was a foul, man. You traveled. Well, who winds up, how do you know if it was a foul? How's that get decided in a pickup basketball game, by the way? For real. Democracy. You all just sort of like, is the weight of the, the other players going to go along with it? Which is sort of what Lincoln says, actually. He says, you know what, if the court makes a decision and the other branches go along with it, and it gets reaffirmed in a few other cases, and it commands like a unanimity on the court, not a 5-4 decision, then maybe we've settled the constitutional question. But unless the other players in the game have all sort of gone, yeah, it was a foul, the question may not be at an end, actually. So now you want examples. You want like modern day examples.
If you can think of any.
If I can think of any. Can I think of any? We don't do this. Well, I should point out, we don't do this often, actually. Most of the time in American politics, people have the attitude that you all do right now, that little straw poll I took. Overwhelmingly, Americans, including people holding office in Congress, including the president, when the Supreme Court makes a decision, go, oh, it's the law of the land. Okay. They're just sort of content to let the Supreme Court play umpire. But when they don't, right?
I do have something I'd like to ask you.
Yeah.
When I was at Hillsdale, they suggested to me that this often happens kind of surreptitiously, not being as direct as Lincoln was. Like they were claiming that since the recent gun control cases at the court, Bruin, I believe, they were claiming that a lot of democratic states which want gun control now, because they're not allowed to do gun control, they're like starting to impose like various restrictions on like bullets and cartridges, and they were suggesting to me, those professors, that this is a form of departmentalism. This is a form of trying to frustrate and get around the court ruling.
No, that's a great point. I think we did this with abortion for 50 years. This came up with, Roe versus Wade and abortion, and technically it took the court 50 years to overturn it. But it wasn't just like silence in that 50 years. Actually, what we had was a long train of states who wanted to regulate abortion stepping in and going, well, let's try this one. Let's ban abortion before 20 weeks. Let's ban abortion before 15 weeks. Let's require a 24-hour waiting period. In other words, they kept imposing requirements to sort of, push the boundary of what the court had identified as the abortion right, and the exact same thing is happening with gun control, right? The court says there's a right to keep and bear arms. That means in some cases there's actually a right to be able to carry a gun concealed, not just, after all, it's the right to keep and bear arms, carry it around. The court sort of put some teeth in that provision and done some very controversial things with it in recent years. And yet, just like we did with abortion, states are sort of like walking up to the line like my 9-year-old and going, how about this? Like, put your toe over the line, right? I'm not touching you. I think the political branches and the states do this a ton. I keep talking about the president and Congress, but we have a federal system where the states have a lot of authority, and they can push back in ways that often federal courts can't do much about. This also doesn't take account of the judiciary anticipating pushback. The court will find creative ways to limit its decisions or avoid making controversial decisions sometimes because they suspect they might not be able to enforce it. Now, identifying those are basically like, those are negative results. They're things that don't happen, so it's awfully hard to put your finger on them. And then occasionally we have collisions between, like, a political party and the court. Like FDR and Democrats collided with the Supreme Court in the 30s and 40s. We haven't really had a full-scale collision between the court and political parties since FDR, probably. We kind of did with Reagan, but Republicans got a bunch of appointments and that solved the problem. But we definitely had collisions with Thomas Jefferson. Jefferson and his party didn't just refuse to comply with judicial decisions, they removed 18 federal judges from office. Obliterated their offices, just said that court doesn't exist anymore, and sent them packing, right? Andrew Jackson had some run-ins with the judiciary, a little famous. So it's rare that these turn into situations where the president goes, I'm not listening to the Supreme Court. There's usually a more creative sort of iteration of this. The fight's usually more complicated, right? Usually plays out in a little more subtle way.
I could give you a couple of examples from the Maple State, the 51st state, and see what you think of them.
Our rebellious cousins to the north. Yeah.
Or the Loyalists. You're the rebels down here, right? King Charles is still my king. What's interesting is
Elizabeth was better. I mean, you got to admit, having
do
to take
admit.
Elizabeth off the money and put Charles on was a bad trade.
Yeah.
But
Yeah.
I have a 5-pound note from England that has Churchill on one side and Queen Elizabeth on the other.
cool.
And I'm not letting go of it because I know they're about to put Charles on the money. And I'm like,
and Tony Blair's.
Okay.
So what's interesting is the federal government, I do not think, has ever used the notwithstanding clause to get around the courts in Canada. But a few provinces recently have in controversial cases, and what's also interesting is that they did this preemptively, because these provinces were pretty sure that the courts would find constitutional fault with their laws, and they're like, we don't care, and we don't even want to give the courts the opportunity to do this, so we're going to pass the law, and on its first passage, we're going to invoke the notwithstanding clause. So the first was in my home province of Quebec in about 2019, I believe, under inspiration from these kinds of secularism laws in France and other European countries. They basically said if you're an employee of the Quebec government, you know, if you work for a government office or if you're a K-12 teacher in a public school, you can't wear visible religious symbols. And a lot of this was motivated, I think it's fair to say, by anti-Islamic animus, but it applies to, you know, all religions, can wear turbans or headscarves or big crosses. And it was pretty clear that the courts would have struck this down as an unreasonable infringement of religious freedom. And in fact, I mean, the Quebec government knew that the chances that this would get struck down were extraordinarily high, so they slapped the notwithstanding clause on it straight from the beginning. Then Saskatchewan, just 2 years ago, one of our western provinces, passed a law because apparently there were some kids in K-12 schools who were transitioning their gender, and the school wasn't telling the parents, and this caused a political controversy, apparently. And the government was on the side of the parents and passed a law saying, schools, if you're going to facilitate the transition of kids under the age of 17, I think, you have to notify the parents and get their approval. And then they were concerned that the courts would strike down this law based on the equivalent of Canada's 14th Amendment. So they slapped the notwithstanding clause on that from the beginning. So I think maybe you hate both of these laws, maybe you like them both, maybe you like one, you hate the other one. But I think the other question is, did it make sense to slap the notwithstanding clause on from the beginning? I mean, this way you're actually avoiding a direct confrontation between the legislature and the courts, because the courts basically aren't allowed to get involved. But if the idea is that you want a kind of reasoned dialogue about rights between courts and legislatures, maybe something is being lost if the courts are being kind of kicked aside from the beginning.
So I'm curious if we provoked any questions from you guys. Yeah, there are some in the back.
Dr. Brogdon was talking about being removed. And so Marbury v. Madison was decided, and nobody really noticed that the court had just basically said, we get the last say, you know, establishing judicial supremacy. It had precedent from England. But I wonder, at what point does the court push too much, and the other two branches, you know, start to challenge that concept of judicial review, and then, you know, go ahead, Mark.
Well, this is great because you know, you're observing that something like Marbury versus Madison, where the court technically strikes down a federal law, but does it to let the president win, right? So the winner in the case is the Jefferson administration. Madison is Jefferson's Secretary of State. And so as far as the public's concerned, you read the newspaper, you go, oh, Jefferson won, right? Supreme Court sided with the president, you know, no biggie. It's kind of like this week, right? Actually, very good parallel, right? The Supreme Court this week said, oh, no, actually a district judge in Washington, D.C. can't issue a writ of habeas corpus over people being held in Texas and deported to El Salvador. If you want a writ of habeas corpus, you got to go to the court. in the place where you're being held, the district, which would have been South Texas. So Trump administration won, right? Well, the court also had a lengthy discussion in there about the due process that people like these fellas that are deported to El Salvador are entitled to under the Constitution. So the court kind of did both. They said, oh, sure, Trump wins, but when this comes up next, just understand there are due process protections for these folks, and you have to adhere to them. In fact, the court in South Texas was this yesterday or this morning, actually issued a new temporary restraining order to say, nope, no more deportations, and by the way, you might need to bring some of those folks back. So it's one way it can kind of slip under the radar. The interesting thing about this, though, too, is, in general, if courts want to sort of like have all of the institutional power to like stand up to the political branches when something controversial comes along, they've got to build up some credibility in a whole bunch of non-controversial cases. So the court's got to spend a good long time deciding things that most people don't notice because nobody's losing sleep over it and it's not all over network news. And they sort of do the workaday, everyday stuff courts do and earn a lot of trust and credibility, and then comes the big collision and they can spend it. If they try to just fight sort of title bout after title bout, they're going to get their brains bashed out. So, sorry for the boxing metaphors. So this is kind of an important observation about the way this sort of thing works. Other questions? Is Brooke any? Noah?
Yeah, you brought up the Lincoln debate over the court. In both your opinions, would it be better for the Supreme Court to decide between the parties or decide the question? And is it up to the court to decide the question because it's been appealed up to that point? Or should it be plaintiff?
This is an important question because some people actually argue in American politics there's no clear constitutional authorization for the Supreme Court to decide a constitutional question. What American courts can decide is cases and controversies. And in deciding those cases, Dred Scott and Sandford, they have to answer certain questions to figure out who wins. And so you only answer the big constitutional question so you can settle the case. But that's not how the Supreme Court actually works now. The court actually picks cases so that they can get at a question, right? The cases just become vehicles for an attempt to settle bigger questions. And you could probably give examples of this, and some countries actually have an explicit authorization for their courts to just answer the question. Does the Constitution require gay marriage? Right? That's just, our courts couldn't do that and said you had to take a discrete case in order for the court to sort of get at the question and try to answer it.
Yeah, I was just going to follow up that. A lot of European systems have what's called abstract judicial review. So various parties can challenge a law even in the absence of a concrete controversy. Sometimes the legislative minority, I think if you get like 20% of the people in the German Bundestag to go to the court and say this law that was passed that we voted against, we think it's against the Constitution, the court's allowed to review it even before it's been applied or enforced in any way. In Canada, we have reference questions. That's when the government itself decides to ask the court for its opinion. And they're technically not binding, but they're treated as binding. But interestingly, the court the government did this with the issue of same-sex marriage. They asked the court, does the Constitution require same-sex marriage? This was a liberal government. They wanted same-sex marriage, but they didn't want to take the heat from voters who were against it. So they were hoping that the court would answer and tell them, yes, the Constitution does require it, so then they could enact it and pass the buck to the court. And then the court was like, we will refuse to answer that question. Although it's not clear that they have the constitutional authority to refuse to answer reference questions, they kind of pass the buck back to Parliament. So that's how the game is played.
Yeah, we have some creative ways of actually doing this anyway in the United States. Like technically, the courts have to wait for the law to be enforced, and then somebody that's been harmed by it has to come in and challenge it in a live case or controversy. But occasionally we come up with really creative ways of fixing this. Like Congress will actually do this sometimes. For example, with laws that affect reapportionment or voting quite often, or the court did this with campaign finance reform, whenever it's tackled it, they'll put in the law a petition or a provision expediting Supreme Court review of the case. So they'll pass the law, and they'll say, if anybody challenges this law, it gets an initial look in the district court, and then it goes straight to the Supreme Court to sort of get it there right away, which to me is basically trying to do something like referring constitutional questions to the judiciary, like Germany does, France does this, India does it, South Africa does it, a lot of them do. One other observation about this, countries, by and large, countries who like authorize their courts to do this, rarely just leave them in courts of law. So what they will quite often do is create a special court that's the only court that can answer these kinds of questions. So the French do this, and to some extent the Germans do, where like the French have a constitutional council, and its whole job is to answer constitutional questions. It doesn't decide legal cases. It doesn't decide lawsuits between A and B. It decides a question that's referred to it by certain people. So that's sort of a way of getting right at the question. In the United States, we're distinctive because we both have this strong review power. Courts can decide what the Constitution means and strike down laws, but it's in ordinary courts of law and in all of our courts of law, like from local trial courts at the state level up through the federal circuit courts and state Supreme Courts and right on up to the Supreme Court of the United States. So we're a little weird in that respect.
Yeah. Yeah, just to follow up on that, most European countries have specialized constitutional courts. Now, most of them, as in Germany, it's still, normal judges, usually law professors who are appointed to these courts. In France, I think the Conseil d'État is composed primarily or exclusively of former statesmen. So I think former prime ministers or presidents of the republic actually are the ones settling these constitutional questions.
Yeah, in France, I think French presidents sit on the Constitutional Council after they leave office for life. And others can be appointed to them, but they're from all walks of life. They're not just lawyers, right? So France went, the Constitution's too important to leave it to lawyers. And so they put, diplomats, scholars, politicians on this thing, which is an interesting approach. That, by the way, is because when France adopted this stuff, and largely in Europe it's adopted after World War II, they had spent decades refusing to have judicial review. They looked at the United States experience with this in the 19th century, the early 20th century, even in the New Deal, and they were like, we don't want any part of that. Like, that's a hot mess. Judges should not be deciding these kinds of huge questions. And they thought, these are not, so one of the things that European theorists would often say, they'd say constitutional questions are not legal questions. They are the most important kind of political questions. And trying to pretend like they're the sort of thing a judge can just apply neutral principles to and decide the same way they interpret a contract or a property statute is just burying your head in the sand and ignoring how politically consequential this stuff is. So that's why Europeans just refused to do this while they were establishing democracies throughout the 19th century and into the 20th. It was finally, after World War II, they all went, I guess we need judges. Yeah.
This said, I think, as important as the institutions are, I think political culture also plays a huge role. I think countries like Germany have established a strong constitutional court, whereas the Nordic countries, I believe, have very deferential courts. So they do have the power to judicially review laws, but they very rarely exercise it. And I believe Japan has also gone down this path where the government wins over 95% of its cases. So both Japan and Germany emulated the United States after World War II by empowering the courts, but the practical results have been quite different.
I think the most fascinating of these middle way judicial review things are the declarations where courts can say, that's unconstitutional, but we're not telling you have to do anything about it. Like where courts can just declare things unconstitutional, but they can't actually command anybody to do anything. They can't say knock it off. They can't force anybody to do anything. It's just, to me, it feels kind of like when you as a parent go, you can make this choice. I'm telling you it's wrong and you're going to pay consequences for it. But hey, if you want to do it, that's on you, pal. Right? And I'm not bailing you out afterward. You know, it's that sort of, and I wonder is that, I would be real, I don't know anything about the sort of research on the effectiveness of this. I'm wondering how often, like, political institutions go, you know, you're right. Maybe we should hold off on this, or at least modify what they're doing to sort of moderate it.
I have seen some research, I'm not an expert, that suggests that in New Zealand, compliance has become the norm. And I would also think that there's a hope that, you know, these declarations could be used for electoral purposes, right? If you have a government that's defied the court like 15 times over the course of 4 years, the hope is that, you know, the other party could bring this to the people's attention during the election campaign and say, look, this is a lawless government. You need to vote them out of office. They've infringed people's rights and they refuse to listen to the courts. So it would hopefully have political effects, even if it doesn't have direct legal effects.
So any other questions? Anybody got other questions about stuff that's going on here? Yeah.
Bringing it back to a point kind of earlier in the discussion, and contrasting America's system with some of these other systems, that allowing the legislature more leeway to get around the court to be fundamentally more democratic. I kind of want to push back against that idea a little bit. Recently, we had the example here in Utah where voters statewide passed ballot initiative to establish a nonpartisan commission to draw congressional boundaries. And the state legislature is doing everything in its power to disarm that ballot initiative, get around it, not have to create that commission. And getting to the point of, and it was the state Supreme Court that kind of stepped in and said, you actually do have to have all of the intent of the ballot initiative. So, yeah, just wanted to highlight the role of some partisan gerrymandering and such. Like, it comes to the question of constitutional amendments as well, where it's not a direct democracy, it's a democracy of the states, right? Wyoming gets as much say as New York or Texas. They all get one vote towards passage of their constitution.
So this is a great point. I mean, you bring up the Utah ballot initiative issue with the initiated statute on a redistricting commission, but you describe the court as sort of standing in between the government and the people to assure that the government actually follows through on the lawful requirements the people have put in place. In this case, the one you're describing is through initiated statute. In other cases, we think of it through a constitutional amendment. That's actually exactly how Alexander Hamilton defended judicial review in the Federalist Papers. Hamilton says, we have a constitution. Constitution's made by we the people. What happens when the government refuses to comply with the Constitution? Well, judges are going to say, that's invalid. You can't do an unconstitutional thing. And the way Hamilton described this was, when the judges do that, they're not doing something undemocratic. They're actually enforcing the settled will of the people expressed in the Constitution against a like temporary will that just resulted from the most recent election. I actually think the initiated statute issue is a really interesting issue to think about this in the context of. Because there you had a ballot initiative, and often as Utahns, we talk about this initiative process, we just say initiative. But we actually, the initiative is for a statute, not a constitutional amendment. So whereas Hamilton's thinking in terms of a constitutional provision that's obviously superior in authority to anything the legislature does, there's an ambiguity in Utah's constitution and in the, I think there's, there's a dozen and a half or so states, maybe upwards of 20, I can't remember the numbers now, I knew them a few months ago, that have initiated statute processes. And there's a kind of unsettled ambiguity there. That is, when the people pass an initiated statute, they are creating a law, but it's a statute. It's not it doesn't change the state constitution. It's just a statute, and it's a statute, theoretically, of equivalent authority with laws that the legislature makes. So it's like the people are like, in that case, a second legislature. They take the power of direct legislation and pass a law and go, this is now law in the state. Well, then the legislature comes back into session. Well, it too can make ordinary laws. And a legislature can typically overturn anything it did the previous session. Like the legislature did some things that I thought were great this last session, and They could come back next year and unwrap it all. They could come back and repeal the bills that I thought, wow, that was great. They could come back and undo it. So the theoretical question that comes up with initiated statutes is, are those just laws? And if they're just laws, can't a future legislature overturn them or set them aside or ignore them or modify them just like they can any other ordinary law? Or is there some special authority that attaches to them because they were direct legislation? Even if the Constitution doesn't say so, is the fact that they came straight from the people give them a special level of authority, and we should prefer that to the legislature's authority? So, I mean, I think this is a great case where the issue of judicial review is really an issue of constitutional enforcement. If we think there are certain laws that are of a higher authority than other laws, who gets to play umpire and make sure people comply with them? And you can see, I think this illustrates how the answer to that question can get really complicated depending on sort of which country we're in and how the Constitution's structured and what kind of thing we're talking about, a statute versus a constitutional amendment and so forth. So that's a good example. But I do think the best defense of judicial review is that the judges are speaking for the people when they enforce the people's settled will expressed in the Constitution. And that's a basically democratic rationale.
Agreed.
Other questions?
It's interesting that that sort of defense comes from a very undemocratic institution, especially on the Supreme Court, considering the way that they're appointed. And I have my own thoughts on the initiated statutes, but it is interesting to consider the, if the people are on that same level as the legislature, why did the Supreme Court say that the people couldn't initiate amendments to the state constitution? Because the legislature can do that, but they explicitly in the decision said that the people couldn't initiate those types of amendments. I was wondering if you could insight into why that is.
Oh, in the case particularly? Well, the Utah Constitution only provides for legislative amendment of the Constitution. There's not a process of initiative for initiating constitutional amendments. So we allow initiated statutes so the people can make laws directly, but they're ordinary laws. If you want to amend the Constitution, you have to involve the legislature in sort of initiating that amendment. So very interesting thing. You point out that, the rationale here that judges can sort of speak for we the people in enforcing the Constitution, sort of relying on an undemocratic institution to achieve a democratic end. Like popular sovereignty actually requires that the people set up institutions that are ironically insulated from the people so that they can then enforce the people's will over the long haul. I think it's exactly the kind of rationale that produced the kind of complex constitutional structures we have. We don't have simple direct democracies, in part because we realized that anyone exercising unfettered, unimpeded power is not going to promote the interests of the people or of liberty in the long run. So it's sort of like the problem of self-control, right? You'll be happier with yourself if you're self-controlled, and that probably means having other people around you with some accountability, like just doing in an unfettered way everything you want will not make you happy, free, decent, and so forth. And it's sort of the same thing with constitutionalism. Like, ironically, if you want to achieve the people's ends over the long haul, you've got to set up a more complicated institutional structure that will actually pursue those ends over the long haul and not just be subject to the whims of the moment, right? Our mood changed this week, so we're going to unravel all the things we've been working on for the last 10 years. That doesn't seem like So I think judicial review is like a piece of that. In fact, the fact that there's a judicial process. I mean, why don't we just have, we have a jury of people's peers. Why don't we just allow the local community to gather in the town square, call up all the people who are accused of crimes, and sort of vote right there on the spot? Should we hang this one? How about this one? How about this one, right? No, that's mob rule. It's democratic, deeply democratic. As democratic as you can get, that is. But we created courts because we realized that actually complicated institutional structures, rules for the game, were necessary. to make sure we did it correctly. You got anything to add to that? Parting
really.
thoughts? We probably need to wrap up.
I'm okay with wrapping up.
Okay. Any last questions? No? Okay, nobody's got a zinger to stump me? There it is. I knew it was coming.
So I'm an accountant, and so what I do is I look at facts and try to weed out emotion as much as possible. But I also don't have like the prowess nor the time to be as involved in understanding the Constitution. And so that's context for my question. My question is, I hear on the news about President Trump seeking a third term, but I hear very smart, athletic people who say, you know, it's in the Constitution, it's not possible, but I don't know, it almost seems like it is possible. So, what are your thoughts on that?
I haven't followed this issue, but it would seem to me that that's clearly prohibited by whichever amendment establishes term limits. Is there a clever argument on the other side?
There's a clever argument on the other side, yes. So the Constitution says no person can be elected to the office of president more than twice. And the cleverness comes in saying, well, there are other ways to become president that don't involve being elected. For example, we have lots of constitutional provisions about people succeeding to the presidency in the case of a vacancy in the office. That can be on account of the person being impeached, booted out, getting sick, resigning, dying, all sorts of ways people leave office. We've actually amended the Constitution a couple of times to deal with that. And the argument goes, so here's the clever workaround, is that President Trump could get himself into an office that's in the line of succession to the presidency, and then the person who's president resign. And then the president could succeed to the presidency in the case of that vacancy. Of course, the easiest slot to do that from is the person next in line of succession, which is the vice president. This, by the way, is how Vladimir Putin violated term limits in Russia. He got term limited out under the Russian Constitution, so he ran for vice president under Medvedev, and then Medvedev resigned, and Putin became president again, and he never left. So is there a bar to doing this? Answer to that is yes. The 12th Amendment says no person shall be eligible to be vice president who is ineligible to be president of the United States. That's not the end of the debate, actually. There are some super duper clever interpretive gymnastics you can do to read that provision as not quite barring a president who's been elected twice from running for vice president. It seems I'm allergic to constitutional interpretations that don't make sense to ordinary people. So if your interpretation of a constitutional provision requires you to read it in such a complicated fashion that an ordinary person has difficulty understanding it, that might sometimes be necessary, like if just the language is that complicated, but I think is a bad idea. In general, if language looks like it means something, people understand it to mean that when they read it, it's pretty much what it should mean. I think that's true with, like birthright citizenship and probably accession to the presidency. But the only other spot, I will say it's definitely possible for Donald Trump to be president a third time if he gets into some other office than the vice presidency in the line of succession and everybody moves out of the way. So that could be Speaker of the House of Representatives, for example. I mean, you have to go down the line. The Speaker of the House, and I think President pro tempore of the Senate, and then the cabinet officers in order of their creation, starting with the Secretary of State. So Trump could become, get elected to Congress, become Speaker of the House, and then the Vice President and President become simultaneously ineligible, and he could move to the presidency that way. That is possible, highly unlikely, and deeply unwise. So there's my that's not 2 cents, it's like 4.5 cents on third term. Okay, well, I want to say in conclusion, I'm really grateful for you guys showing up. This has been a lot of fun to chat with John. John has been a postdoctoral fellow with us. That's part of the Civic Thought and Leadership Initiative here at UVU. in the Center for Constitutional Studies, which is a program that the Utah legislature established back in 2021 and has borne tremendous fruit in bringing people to UVU's campus and into Utah civil society that help us equip people for constitutional literacy, civil discourse, having serious conversations about things that are important to all of us as American citizens and Utahns, and the wonderful folks who visit us and spend time with us as residents. You know, the Center for Constitutional Studies does a lot of this kind of work. We try to convene conversations like this. Sometimes it's in classes, sometimes it's with K-12 educators. We also do it in big events. So when the fall semester rolls around, keep an eye on our events page on the CCS website.